All right, welcome to The Explainer. Today, we're diving into something that affects almost everyone. What makes a promise legally binding? We're going to break down two massive concepts in contract law that determine whether a promise you make or a promise made to you actually has a price tag. So let's get right into it.
So think about it. Why is that handshake deal you made at work something you could go to court over, but promising your friend you'll help them move next weekend? No, probably not. What is the actual legal difference? The whole answer is wrapped up in what the law calls the price of a promise, and that's the absolute key to making a deal stick. And the law's first big answer to this question is this one crucial concept: consideration. It sounds a bit formal, but the idea is simple. For any promise to be a real enforceable contract, it needs a price. It's got to be a two-way street, not a one-way gift.
Okay, I know, that is a mouthful of legal jargon from a case way back in 1875. It sounds super complicated, but trust me, the idea behind it is actually pretty straightforward. It's all about exchange. It just means that everybody involved in the deal is either getting something or giving something up. Exactly. So the bottom line is this: a simple, one-sided promise is legally just a gift. But a promise that's baked into a two-way exchange, a bargain, that's a contract. And that little thing of value that's being exchanged, well, that's what lawyers call consideration. So if every promise needs a price, what does the law actually count as value? This is where it gets interesting, because it's not always what you might think. Let's break down three key rules that the courts use to figure this out. First up, timing is everything. You generally can't make a binding promise to pay for something that someone has already done. Take the case of Rima Gardel. Someone fixed up a house, and afterwards they were promised payment. The court said, nope, too late. But look at the flip side. In a much older case, Lampley v. Braithwaite, someone did a favor at the other person's request. Because the request came first, there was an understanding of payment, so the later promise to pay was totally enforceable. See the difference? Okay, now for a really fascinating rule. The law says consideration must be sufficient, but it doesn't need to be adequate. What on earth does that mean? It means the courts do not care if you made a bad deal. They just need to see that something of real tangible value was exchanged. So in one case, a son promising to stop complaining wasn't good enough. It had no real economic value. But in the famous Nestle case, chocolate bar wrappers, literally trash, were considered valid consideration for a record. Why? Because they had some value to the promotion, and that's all that mattered. All right, what if you're already supposed to do something? Can you be promised more money to do the exact same job? The classic rule says no. In Stilk versus Myrick, some sailors deserted a ship. The captain promised the rest of the crew extra pay to finish the voyage. But the court said they were already contracted to do that anyway. But then you get a case like Hartley versus Ponsonby. So many sailors deserted that the voyage became incredibly dangerous, way beyond the normal call of duty. Because they were going so far above and beyond their original job, the promise for extra pay was enforceable. But of course, the law evolves. The more modern case of Williams versus Rafi shook things up a bit. In that case, a contractor was promised extra money to finish a job on time. Now, technically, they were already supposed to do that, but the court said the promise was binding because the other party got a huge practical benefit out of it. Specifically, they avoided paying a hefty penalty if the project was late. So this practical benefit idea became a new, more flexible way to look at things.
Now, these strict rules of consideration, they can sometimes create some really big problems. What happens when following the rule to the letter leads to a result that just feels totally wrong? This really comes to a head when we start talking about paying off debts.
So get this, there's this super old rule from 1602 that says if you owe me, say, $1,000, and I agree to take $800 to call it even, that promise I made isn't legally binding. Why not? Because you didn't give me any new consideration for my promise to forgive that last $200. You were already supposed to pay me the whole amount. It's a harsh rule. And if you want to see just how harsh it can be, look no further than Folks v. Beer. Here, a creditor, Mrs. Beer, promised she wouldn't charge interest on a debt if the main amount was paid off. The debtor, Dr. Folks, did exactly that. And then what happened? She turned around and sued him for the interest anyway. And because the court had to strictly apply the rule of consideration, she won. You can see how this created a massive fairness problem. So how does the law fix something like this, where its own rules create an unfair result?
Well, it has a sort of secret weapon called equity. It's a branch of law designed to step in and ensure justice. And its solution here is a powerful idea called promissory estoppel. You can think of it as a kind of fairness shield. Now, this idea didn't just appear out of thin air. It was built up piece by piece over centuries. It all started with that problem from Pinnell's case. And then the idea started taking shape in other cases until it was finally all put together in the famous High Trees case. That's the one where a landlord was estopped, or stopped, from demanding full rent for a period where they had promised to accept a lower amount during World War II. But you can't just use this fairness shield whenever you feel like it. There's a pretty specific checklist. You need an existing contract to start with. Then there has to have been a clear and unambiguous promise. The other party must have relied on that promise. And here's the kicker, it has to be genuinely unfair for the person to go back on their word. It's a tool judges use when the situation really calls for it. And that brings us to the most important thing to remember about promissory estoppel. It's a shield, not a sword. This is the golden rule. It means you can use it to defend yourself when someone is trying to enforce their strict legal rights against you unfairly. But you can't use it to create a new cause of action, to start a new lawsuit out of nothing. It's purely a defensive tool. Okay, let's step back and put this all together. We have consideration, this set of strict rules for what makes a bargain, and then we have promissory estoppel, this flexible safety net for when those rules go wrong. So how do they fit into the big picture? Think of it this way. Consideration is the engine that creates a contract. It's the sword that gives you the right to sue and enforce that deal. Its whole job is to make sure there's a real bargain in the first place. Promissory estoppel, on the other hand, is like the legal emergency brake. It's the shield that you use to stop the system from running away and causing a deeply unfair crash. It doesn't create rights, it just prevents injustice. And all of this leaves us with a huge fundamental question that courts and lawyers argue about all the time. What's ultimately more important? The certainty and predictability that comes from sticking to strict rules like consideration, or the flexibility we need to get a fair result, which is where promissory estoppel comes in? This tension, this constant balancing act between rules and fairness, is really what's at the very heart of contract law.